Folks, welcome in the ring. A very good evening to each and every one of you. A very good evening to each and every one of you. Welcome in the ring. This is our special coverage of Decision Day, Elections Petition Ruling on Preliminary Issues. And we are going to be joined this evening by Senior Counsel Royce Ford, Member of Parliament, who is going to walk us through some of what we heard today and let us know where we go from here. Today was Decision Day, ladies and gentlemen, and we have been discussing this issue of the preliminary matters and the ruling of the Chief Justice on the two elections petitions 88 and 99. Today was Decision Day, folks, and decisions were handed down, and we want to hear from the attorneys on the elections petition case what transpired. Mr. Royce Ford, a very good evening, sir. Welcome.
Hi, good evening, Sherrod. Thank you for having me on your show.
If I'm not mistaken, this is your first time in the ring, and you're a heavyweight by any measure, Senior Counsel.
Thanks, Sherrod.
Mr. Ford, we went through this issue, went through the ruling, rather, of the Chief Justice just this afternoon, who started laying out her ruling from about 1:30 right up until about just after 3 o'clock this afternoon. At the end of it, there were some decisions made by the High Court. Could you tell us about those?
Well, Sherrod, in relation to the first two matters that I would like to deal with, the two petitions, 88 and 99, the Chief Justice ruled that petition 88 is in order and it should proceed to a hearing. In relation to petition number 99, unfortunately, the Chief Justice ruled it is not in order and that it should be dismissed. Chief Justice also ruled, well, apparently made an order, wasn't hearing her clearly towards the end, but seemed to have made an order first that the certain documents, electoral documents, that they be preserved and not destroyed, and that in relation to the statement of polls or statement of recounts, or both, that they should be laid over with the registrar of the High Court.
Yes, I'm picking up that bit of reporting out of Demwara Waves, who indicated, as you said, that the statements of recount, statements of poll were asked to be in the custody of the High Court, and also some other documents which seem to have some concerns. I want to just read a part of the Dem Waves reporting. It says that the High Court has ordered GCOM not to destroy any other document connected to the March 2nd general and regional election until the petition is heard. And the orders were issued at the request of Senior Counsel Douglas Mendez. Yes, sir.
Yes. Well, in relation to that, Sherrod, it is not likely that any documents would have been destroyed. Once an election petition is ongoing, as these are, in relation to petition 99 and petition 88, no documents can be destroyed. So it was an unnecessary application, in my opinion.
Very well. It seems to be a little absurd in a sense, because I just want to quote another attorney at law who picked up on this, and this is attorney at law Ryan Crawford, and he would have said on social media just a little bit earlier, the Chief Justice should not have dismissed the claimant's case on procedural ground for service, error for service. Personally, I don't care, but this case is about the most important public office, and it should be heard on the merits or lack thereof. At the end of his statement, he said he went through this whole issue of documents even go missing at the Magistrates Court and at the High Court.
Well, Sherrod, in relation to the order that the Chief Justice made in relation to the dismissal of petition 99, it centered around the service or the non-service of the petitioner, Mr. Granger. I would like to take an opportunity, if you would allow me, to just
go right ahead, sir.
Take us through.
Go right ahead.
Sherrod, when the petitions were served, they were served on all the respondents. They were served on all the respondents in time. The next stage, as required by the law and the rules governing these matters is that an affidavit of service must be filed in respect of each person served. This was done. Rule 9.5 of the rules, the National Assembly Validity of Election Rules, does not specify a time frame in terms of a fixed period, a week, 2 weeks, a month, or any time. But it says must be filed as soon as is reasonably practicable. As far as I recall, though I appeared in petition number 88 in relation to petition number 99, the team of lawyers in both petitions ensured, to the best of my knowledge, and I know this as a fact, filed the affidavits of service within 7 or 10 days after service. That is to say, the most 12 days after service on each respondent. In relation to petition number 99, when the matter first came up, the Chief Justice indicated that she felt that there was a problem with petition number 99 in relation to the petition being served on Mr. Granger. I recall Mr. Mayor Robertson indicating quite clearly and very upfront that must have been some sort of problem. As far as he's concerned, all these matters were served and served in time. When the affidavit of service was done in relation to Mr. Granger, apparently there was an error recorded in the affidavit with respect to the date upon which it was served. It apparently said it was served on the 25th, when in fact it was served on the 18th. A supplementary affidavit, which is a standard supporting document when there's an error in an affidavit, was laid over with the court. The court today, in a decision of the judge, the Chief Justice, the Chief Justice said, in her opinion, that it was required, that leave was required to file a supplementary affidavit. There's no provision in the law, as far as I know, in relation to filing any matter in relation to an election petition and an affidavit for service, that you need to file an affidavit or a supplementary affidavit only with leave. That was in fact done. The Chief Justice took the position.
Well, just give me one minute. Let me invite Mr. Kemraj Ramjatan to the discussion. And Mr. Ramjatan is also an attorney at law by practice and by profession, and he's one of the attorneys on elections petition cases. Good night, sir, and welcome.
Thank you very much, Sherrod, and glad to be in the ring tonight with senior counsel. He was speaking. Let him go ahead.
Yeah, sure. I was saying that in relation to the affidavit of service, it was filed. It was filed in compliance with the requirements. There was an error in the affidavit. It said the 25th instead of the 18th. And a supplementary affidavit was filed, and there was no requirement for us to obtain leave from the court to file a supplementary affidavit. So when the Chief Justice took the position this afternoon that leave was required, it is a position that I don't support. I believe, with greatest of respect, the law does not support that you need leave to file a supplementary affidavit. The failure to file and obtain leave, in the court's opinion, rendered the fact that the first affidavit remained on record despite the supplementary affidavit was filed, and it was filed correcting the date as required. Now, Sherrod, there's no need for leave to be granted by the court to file a supplementary affidavit. Rule 9.5, which governs these matters, says that it should be filed as soon as is reasonably practicable. When we discovered the error, the affidavit was filed, the supplementary affidavit was filed within a month. From the time the petition was filed to the date when the affidavit was served, I don't believe 3 months had expired. In previous cases decided by the High Court, which the High Court rejected efforts to file an affidavit of service under the same Rule 3.9, would have been periods of a year and upward, 9 months and upward. This is a situation where within a 3-month period, recognizing an affidavit had a problem, a supplementary affidavit was filed to indicate the correct date upon which it was done. Now, interestingly, Sherrod, and Kemraj could point out if I'm wrong here, there is not a single other piece of evidence filed by any person whatsoever indicating that Mr. Granger was not served on the day when it is sworn in the second supplementary affidavit that he was served. So these matters are to be decided on the evidence The evidence was that Mr. David Granger was served and was served with the affidavit, with the documents, and that was recorded. So in my opinion, I see no difference between the circumstances in relation to service, in relation to Mr. Granger, and the circumstances in relation to service, in relation to the other respondents, that the same Chief Justice found service was properly effected, because they raised all sorts of contentions in relation to 4 other respondents. The 1st, the 8th, the 9th, and I believe the 12th. I must check back my notes, which the Chief Justice dismissed. So we had a situation where, despite the fact that there was evidence before the court of service, there was no contradictory evidence to establish that he was not served when we said that he was served in the supplementary affidavit. The Chief Justice found that because we did not obtain leave to file a supplementary affidavit, that we somehow erred there, and that the only affidavit that was left standing was the initial affidavit that was left standing. So I believe that we were able to competently cure the defect in relation to the first date in the affidavit, and we properly had before the court evidence indicating that Mr. David Granger was served. You know, Sherrod, the fundamental issue which the Chief Justice recognized in relation to the other respondents, but unfortunately, in my opinion, did not apply the same principle, is simply this. In relation to affidavits, the court looked at the totality of the evidence. And on the totality of the evidence, the court found that all the other respondents were served. In relation to the totality of the evidence in relation to Mr. Granger, there was no evidence to show that he was not served. All the evidence indicated that he was in fact served within the time frame, and that the affidavit of service, the supporting affidavit of service, was not filed inordinately long or outside the period or outside the contemplation of this section.
Yeah, I want to commend the articulation of the reasoning here of senior counsel, because it is important to understand that the justice of the case more or less required that before you can find in the way the judge did, you had to find some evidence that is forthcoming from some other that will controvert that indeed the 18th was the day. Initially, there was this mistake, and of course that was cleared up by the supplementary. I want to endorse what Roy Zilford Sr. has indicated here, and to say that that ought to have been the approach. What are the consequences here of a mistake being made? And look, these things sometimes happen almost every day in the courtrooms that you have. But I rather suspect that, she took that position because she felt that it was so strict that without anything coming, and you know what? We had a position whereby Jagdeo had wanted to indicate via his lawyer that is he, Jagdeo, who wasn't served properly. That was initially the whole plank. But of course, we then found this out, and at the earliest opportunity. I remember the Melville case, which was the AFC seat in Region 10. That one was served a long time, and I think it's a year and a half after. And what is very much in the process here is a section of the law that says, as early as possible, you can serve your affidavit of service, or as the case is in here, a supplementary affidavit of service. I was very disappointed with that aspect of the reasoning, and knowing that it can suffer the consequence of the whole case going overboard, striking out being a consequence. But of course, thank God we can have an appeal, and that will be done, and we will hear 3 other judges who will probably exercise a discretion that is very much different. I believe it is a discretion here. Your Honor, this afternoon indicated that it is going to go the way of exclusion without any controverting evidence. That's the big point here. But, well, that is how these cases sometimes go, and that is why you have an appeal. And I think that is the best way, carry that ground for an appeal.
On the issue of service, which is the central issue in the petition 99, it was the judge, if I remember clearly, it was the Chief Justice who raised the issue in the preliminary issue she was teasing out of the matter during the case management of whether or not Mr. Granger was really a respondent in this matter, should be a respondent. And I think it's on that basis, the thing, you went back and had another look at it, because he was not at cross purposes with any of the arguments your team was making. And then it seems very strange that the Chief Justice came back this afternoon and reasoned it from the other side to say that, from the leader of the list and all of that, that he was a proper respondent in the matter and should have been served properly.
Yeah, well, that is also surprising a ruling, because look, the fundamentals of why a person is a respondent, or the essence of it, is that their interest must not in any way be different from the interest of the petitioners. That is what that section 4.2 is all about. And essentially what is being asked of us was to address that issue, and it was addressed, because indeed we indicated that almost everything, very much everything that the petitioners are asking for is really what the David Granger is asking for. And to strain an argument, I would like to make the critique of her reasoning, is straining an argument to find that there is a conflict, or there is some collision with the interest of the petitioner. And it went a little too far. There was an overreaching in relation to that aspect of the matter. And again, I think it will be a very, very sound ground of appeal in relation to that. And more on that at the time when we start the arguments there.
But one of the things I would like to add, Sherrod, is that at the end of the day, the Chief Justice said that there were inconsistencies. I might have missed some part of the judgment, inconsistencies in relation to service. But what was undisputed today in the evidence before the Chief Justice is that there was no dispute as to when Mr. Granger was served. There was no dispute on the affidavits. He was served on the 18th. The affidavits said that he was served on the 18th. The affidavits indicated what were the documents that would have been served on the 18th. There was no other evidence indicating that Mr. Granger was served any other day. So the test to be determined, as the Chief Justice applied a test in relation to the other respondents, whether on the totality of the evidence, you can come to the conclusion that all the documents required were served and served within a time period as required.
And it's on this very point that the Chief Justice seemed almost livid that there were so many, paraphrasing what you would have said, so many errors in terms of this service. You went on one date, you forgot to get the document signed, and then you went back, you had it signed, and then you forgot to put the date in. And she was almost livid on this point. And one thought that that the interest of justice being served, as somebody said earlier, and I was quoting on social media, this is the highest office in the land we're talking about, electing an individual to that office, and that the other aspects might have paled in comparison of getting justice for the people of this country as to really and truly what transpired on March 2nd in the general and regional elections in this country, as against trying to put this stumbling block of service. And I can say that the man in the street cannot fathom that you would not hear the merits of the case, but it's how you brought the invitation to the court that seems to trump the day as against whether or not I was wronged.
Well,
And that,
Sharon,
yeah,
you go.
go ahead. No, I was trying to make that is what a number of cases have indicated. Get on with the merits rather than these what you call technical issues. Get on with the merits. That is what elections petition. Why you carry all the war against each other on the streets into the court in an elections petition, and you ask there. All right. Well, if he was not served on the 18th, you, Mr. Barajagdeo, or the lawyer, when was he served? What are you trying to say here? We have a problem, but they're maintaining their service. Well, what is the big thing? Let us get on with the merits of the matter, and it's the merits that you have to get on with. But she quoted extensively the passages from previous cases that says that these things are strict, but the strictness there we are not denying. We are saying that there is not any evidence controverting that Granger was served in the 18th from any independent source or from those who are making the allegation, things like that. And you could very well get a Court of Appeal ruling that that should not be the case. It should have been a case where you just roll on with the proceeding with the petition too. So let's hear them, because that is the fundamental gravamen of the case.
And let's right ahead, Senior Counsel.
That is exactly what I was going to say and follow up from what Kemraj is saying. The fundamental issue is that there are parts of the issue of law in relation to an election petition for which you must comply with, and you must comply with strictly. You must comply with filing a certain number or different types of documents. You must comply with filing it within a particular time frame. You must comply with having it served within a particular time frame. So that is what is essential. The court's jurisdiction is invoked when those things are satisfied. So once you get past those hurdles, the court is bound to hear the election petition. In this case, we got past all the hurdles. We presented the court with the proof of service. We corrected it to demonstrate that it was served, because the law in relation to election petitions and most matters is not to punish you if you made an error. Is to ensure that the merits of the matter would be heard and determined, and in relation to the election petition, it is identified what are the criteria that you must satisfy. It does not say that an individual cannot make an error. Imagine, Sherrod, imagine this. As Mr. Jeremy pointed out in these matters, the public will form their own conclusions and could gesticulate and make all sorts of assumptions. But this is a real world with real stress and real issues. And in an election petition, you have to file 12 or 13 affidavits within a particular time frame. You have your staff working. Imagine your secretary makes a mistake and put 19th instead of the 18th. There's a team working, it slips them, people are tired, whatever reasons you want to attribute to it. And it is filed before the court. Now, this affidavit is not one saying that we're now going to serve outside of the time period. It is an affidavit saying when it was served. And a supplementary affidavit is saying, Judge, it wasn't the 19th, it was the 18th. The law in relation to elections petition does not contemplate that you can't make an error, Sharon. That is why there's no time period fixed for the filing of an affidavit. It is an affidavit of service. You have to serve within a time frame. But there can't be a problem if a typist makes a mistake and put the 15th instead of the 16th when it was in fact served. So your whole petition gone, even though you served it within time. That is why the law does not fix any time for the filing of an affidavit of service. And it encourages you to file the affidavit of service. Whatever it is, file your affidavit of service within a short time frame, as soon as is reasonably practicable. And I started off saying, Sherrod, much earlier tonight, that this affidavit of service, the initial one, was served within 12 days of the initial service on all the respondents. Recognizing that, it was corrected. There is not a single provision in any law whatsoever, and I challenge anyone to show me, there's not a single provision in any law which says that you must obtain leave of the court to correct an affidavit.
That's right.
You can't go and correct the service which you did not serve, but on the evidence before you, it was served. So there's an error in an affidavit, and it is corrected. What the Chief Justice decision is today is to say that we did not obtain leave of the court to file a supplementary affidavit when we don't need leave to file it. Therefore, the only affidavit before the court was the affidavit that had the wrong date. So even though it is corrected, and it's corrected not in an inordinately long time,
Right.
We are held to an affidavit which is bound to say the wrong time and the wrong date. So there's no evidence. You know, Sherrod, we might have made history again today. We might have made history again today in the world. Because I know of no case where an election petition would have been dismissed for failure to file an affidavit of service when a supplementary affidavit is standing. The affidavit is standing. The affidavit is before the court. It is not as if one, as in the case of Walter Melville, I believe that was in 2006, Kemraj,
That's right.
where the affidavit of service was being sought to be filed. I believe
a year and a couple of months.
A year later. That is when it was actually filed, or then being tried to be filed, being sought to be filed, or there's some effort to have it. And there was an earlier case, I think Payne or something, which was sought to be filed about 9 months after. In this case, an affidavit of service was filed. So there was compliance. Whether it says the wrong date or the right date, an affidavit of service was filed. Consequent of filing an affidavit of service, we have no leave provision requiring us to correct that affidavit to obtain leave of the court. So when we file a supplementary affidavit, we did it within a reasonable period of time. The only discretion that the court could exercise is if, looking at the time period from when you were supposed to file the first affidavit or when you file the second one, what it is would have operated to prevent you from doing so. So within a month, this supplementary affidavit was filed.
And even if we pass that hurdle in terms of service of the petitioner, Mr. Granger, it seems as though the Chief Justice would have put a second hurdle there, because she went on to talk about all of these other people in her estimation and judgment who should have been served. All of these persons who are going to be affected one way or the other by the elections, petition members of parliament who would have gone and taken up their seats, and councillors at the RDC and the municipal level. What were your thoughts on that count? Because it seems as though you would need a longer period than the period allocated by law to serve all of those persons, based on the simple fact that a lot of persons try to evade service too.
No. We're not required to serve on all those other persons. I believe what the Chief Justice was trying to point out at that time, if I recall clearly, is that in relation to those issues, that Mr. Granger's interest was not inconsistent with the petition. I believe that Mr. Granger's interest was consistent with the petition. He was not opposing the petition. There was nothing in the petition that he could have opposed. In relation to the RDCs, the elections petition does not affect the RDC. The RDC fall under the Local Democratic Organs Act, for where there's a provision there if you want to challenge the elections for the RDCs there. This is in relation to the members of parliament and the election of the president. So I believe something went wrong there.
And you said there the response of Mr. Granger did not or does not oppose the petition in any way. I think it's even, we can go forward and say that there was an affidavit filed to that effect too.
A notice.
A notice was filed to that effect.
That's right. That he will not oppose the petitioner, and that also ought to have been taken into consideration, in my view, to positively stating that he was not a proper party. But look, this is what is important here, is to ensure that we, as I told you in another program, that even if the ruling is against us, bringing finality, certainty, and so on to the law is an important thing. And if that is what we are going to get by filing an appeal, it is very, very important. Because these matters in Guyana will remain a democracy for years to come, years and for eternity, I hope. The trouble, however, is that if we do not carry these matters up, appeal them so that we can get the certainty and finality to them, we would be doing an injustice to the jurisprudence in itself, and an injustice to future generations of list representatives and political parties and a whole lot of other things. So that is why I must say this afternoon, I was in agreement that we will have to file our appeal, file it, and then proceed. And we will go on. Go on.
Because as we were discussing, a lot of people, and every guy needs to have a right to have an interest in the outcome of this case. Because in this election, you had over 3,000 migrants who somebody would have voted fraudulently in their stead. You had over 1,000 missing oaths of identity. This is when you don't have your ID card and you swear by this oath. You had over 1,000 of that which somebody used, and the person did not, they could not, either could not find them or could not find the poll books that documented their use. They also had unverifiable oaths due to missing poll books, unstamped ballots, missing poll books, and missing certificates of employment, among a host, a plethora of other issues that Guyanese need answers for, as against simply trying to strike out an elections petition on a technicality. Where is the justice in that?
Yeah, well, that's the question we are answering here, and indeed, in accordance with the our system of justice. If you don't like what the Chief Justice did today, and we don't certainly, I was very disappointed, we will have to carry it up. We will give our reasons, as we are now doing. We'll give our state of mind, as it were, very disappointing. And but we have to now go on to the next phase, which is, in relation to 99, file an appeal to the Court of Appeal, and there ask 3 judges that will sit whether indeed the discretion exercised here was a lawful one and one reasonably made, and the interpretation of who's a proper party and all of that, whether that was properly done, or, as we would argue, that it clearly was not the case, and so that we can get a ruling that is favorable to us. I am certain that if you do that and you win in the Court of Appeal, they will carry it to the CCJ. And that is how justice is done ultimately. The supreme apex authority will then make the ruling, and then we all will know what the law is in relation to these matters, proper authorities, when and where you can file affidavits to correct a simple mistake that was made, and so on. And that kind of thing. So I think, you know, the justice is in the fact that we have a right of appeal.
Great. Now on to, go ahead, Senior Counsel.
Yes, and we must appeal. You know, that is how the democracy is strengthened. That is how the jurisprudence grows, and that is how injustices are resolved.
That's right.
Fantastic. On the issue of Petition 88, which was successful, it seems to be even on the approach and the strategy here, it was a brilliant piece of reasoning to have 2 petitions as against 1. And we know now that Petition 88 at the High Court level has been successful. Tell us what is at the heart of Petition 88.
At the heart of Petition 88 is the constitutional validity or invalidity of Order 60 of 2020. That is a legal document that was crafted by the Elections Commission pursuant to Section 22 of the Election Laws Amendment Act of 2005. We have maintained and we continue to maintain that that order is unconstitutional. So we're challenging the validity of Section 22, and consequently, we're challenging the validity of Order 60 of 2020. We maintain in the election petitions that these sections, the order would be wholly unconstitutional and would not empower the Elections Commission to make the order under which the recount took place.
Mr. Ramshan, anything to add?
It is reminiscent of the arrangement that happened, which was by consent by the PDP and the PNC, to have a valid voter ID card in that previous matter in 1997. You remember in the Esther Pereira case. And in that case there, although we had passed legislation making voter ID cards separate and apart from the ID card that we normally have now, as the basis for you to get in to vote, to become an elector, although there was consensus, 100% support in Parliament, it was ruled that that was unconstitutional on the ground that the Constitution made some qualifications, one of which did not include a voter ID card. You just had to be 18-year-old and a citizen of Guyana. And we were now, by virtue of a law, stating something else, a third requirement. And indeed, that was what really, was the threshold that ought not to be crossed. I think it is in a kind of a similar authority here, or on the basis of that authority, we are arguing that, look, notwithstanding it might have been consensual, you have the situation whereby it is still unconstitutional, and as a result, certain things and consequences flow from that.
I just want to add to what Comrade said. I just want to recall that there was the matter of Julita Moore, I believe it was, where the Court of Appeal ruled that there could be no consensus, there could be no agreement between the political parties to have a recount. After that decision was made by the Court of Appeal, the Election Commission resorted to Section 22, saying that Section 22 empowered them to have a recount. And it was under that empowering provision that they said that they had in Section 22 of the Election Laws Amendment Act was Order 60 brought into effect.
Okay.
Indeed. Mr. Ramshan, what do you make of the High Court asking for these statements of poll, the statements of recount, and ordering also that no document is destroyed from GCOM during this period when this matter is being heard? It seems to be that we all know what was contained in the statements of poll in the ballot boxes, down to the last.
Exactly. I get the lawyers on the opposing side of the elections petitioners case, I think also want a little propaganda effect. Right now in Guyana, they're always asking people like me, why you didn't show your statement of poll, and so on. Well, I had answered that I didn't get to see the entire lot, but whatever it is, these issues that arise in petition number 88 do not in any way demand, in my opinion, a call for the SORs or the SOPs. You understand? And I think that the call here is going to be made in relation to some other issue that, though it is unconstitutional, say that the recount is unconstitutional, we still got the numbers. And look what the numbers say at the recount. Well, if they're going to bring that recount numbers into the play, we're going to say, well, fine, we will. I am thinking it through that we will then bring the rebuttal to say, but in addition to the numbers as the recount proved, it proved that there was the credibility of the entire thing, the transparency, the number of irregularities that happened was so many that you can't call this thing proper. And that if they want to bring in SOPs, they might very well get us wanting to bring in all the reports as to what happened. Because I think
that is my other question.
Yeah.
No, I was going to say that was my other question, that the petition 88 seemed on the face of it to be a less evidential petition needing evidence. And now, requiring the SOPs and so on seems to be evidence to me. And if there might be a way for us to get the same evidence we would have lacked to bring to court in 99 in the very same way, if it proves the issues that we are litigating.
Yeah, well, you don't want to argue a case in public before a Sheriff Duncan as a judge here. But the whole point of it is that these are legal issues only, as I understand the petition 88 from Rosedale. And it being legal, it's just like the voter ID card issue in the Esther Pereira matter. We go to the legality of the recount, the legality of that order or the section under which they act, and so on, and to get that going. Because once you ruled, let's say, it is unconstitutional and so on, that's the end of the matter. You don't run back now to say, well, bring the statement of full, let me count them. No, yeah. I feel that once it is held unconstitutional, then that is the end of the matter. Fresh elections should be called because it was unconstitutional, just like the voter ID card.
Right.
Yes, Sharon. I'm laughing at what Kemra just saying, how he's putting it over. And again, he's correct. You know, the PPP wants to bring the evidence, and let us tell them, no, we ready, we ready, we ready. And we ready. I'm going to say it one more time, we ready, Sharon. But let me say this. The PPP wants to bring evidence for two reasons. First, they want no early definitive determination by the court of these elections. They want to bring hundreds and thousands, if possible, of witnesses to say all sorts of nonsense, ridiculous things, so as the days go by, they could continue to be irresponsible in government. They could continue to abuse the Guyanese people. They could continue to do and make sure that there's a failure to have investigations of crime. They could put their hands on the resources of the country and to enjoy themselves and their families. So they want to use the election petition that we filed as a device, as a mechanism and a scheme to elongate themselves into power. That is why I pointed out to the court very respectfully today, this afternoon, that this is not their petition. If they wanted to challenge something, if they wanted to bring all the evidence that they have, they should have filed a petition. And they can't determine how we should raise and address the issues which we want to have articulated and determined by the court. So that is the first reason why they want to bring this thing. And the second reason is because they were hoping somehow that they could make the entire process into a circus. But if the court ultimately rules in that direction, the evidence, as Kemra says, of all that has really and truly happened and documented in the recount period will be brought forth. I don't know the relevance of it in relation to the petition and the issues that the court ultimately has to determine. And that is why the court exercised great caution in ensuring that the issues are dealt with in terms of the submissions first.
Thank you for that intervention. Can Kemraj spoke to this a little earlier, but I want you to kind of expand it, because there are a lot of people who feel as though, you know, whatever is the logical outcome of either petition means that we're going to swear in somebody the day after that, and not seem to think that there's another route that must be traveled, another road that must be traveled. Tell us what is the logical conclusion of the success of either petitions on appeal or on the present course of 88?
Well, the logical conclusion will be, in my opinion, and this is my opinion, I wouldn't want to say that I'm 100%. It would be like happened in the Esther Pereira case, a call for early, fresh elections. And as we are saying to 𝐓𝐡𝐞 a couple of days ago, we also would like to have a brand new voters list starting, you know, a period of registration and all of that. So ultimately, it will be for the court, having decided whether the recount and all of that was constitutional or not and whatever. If it is in our favor, we are not asking that by virtue of a court order that you're going to install somebody in parliament or install somebody more somebody else in presidency. It will, as I feel, all elections petition, it will end up having what is called fresh elections called for. And I was at pains last night with you to explain that to the members yesterday afternoon, myself and Amanda and yourself. And that is where ultimately it will go. And that is why we want it to be done expeditiously. And that is why I find that the PPP is carrying on with their lavish spendings and giving away of contracts for $100 million there. Cormac having $30,000 per month for public relations and so on, and lobbying service, not for the government of the day or the people of Ghana, but for the PPP, with a Biden administration that is coming to town on Wednesday. So it is important to understand where all of this is going. There is a certain propaganda impact. There is a certain public relations impact. There is a certain thing that they, certain positives that they want to get out of the process. But all we are asking ultimately is that whether when the petitions are come to an end, have all come to an end, that there be early fresh elections. And then we go to the polls and we hope that 𝐓𝐶OM does not suffer the same, cause the Guyanese people to suffer the same pains and political parties to suffer the same pains as we went through in that period.
Royce,
I substantially agree with Kemraj. What I want the public to know is that ultimately these matters come down to the exercise of a discretion, as we would have seen today. This is not a question of a breach of the law. This is not a question of established principles, established and clear legislation being breached. This is the exercise of an interpretation on an issue which I believe is very clear. And in terms of the consequential relief that could be ordered, yes, a new election petition could be ordered. New elections could be ordered. But the whole range of things, what are the consequences, are completely up to the court. And unfortunately, it is not up to the lawyers necessarily to ensure that what we ask for in the petitions are ultimately granted. For example, one of the orders we ask for is that strictly have regard to the fact that in relation to petition 88, if we go back to some point, if the law is not complied with and a declaration was made, it may well be open for the court to order that Mr. Irfan Ali demit office, that the government demit office. All these issues, which I'm mentioning now, Mr. Ramjatan opposed them at the time when he was in the PPP.
PVP.
I was a very young lawyer then, working with Mr. Dickey. When we had to decide what are the consequential orders. Remember, Kemraj?
That's correct. That's correct.
Orders that would be
In
made
the Superior matter.
in the Superior matter. So so the court did not toss the PPP out at that time, but there was nothing necessarily stopping the court from doing it. It was the exercise of a discretion. It was almost the end of the 5-year period, and elections were almost constitutionally due at the time. I believe it was Cameron.
That's right. It was coming around the same time.
Royzel and Kemraj, I think one of the things, if I remember correctly, underpinning this discretion is reasonableness. So, in your opinion, the Chief Justice was not reasonable in the exercise of that discretion this afternoon.
Well, look, that is the point we are making. We are saying that there was, but you know, the Chief Justice is an extremely good lawyer, and she gave her reasoning. And of course, in our system of law, only a court higher than her can overturn her, overrule her, reverse her. And that is what we were talking about here. So I didn't like the fact that she used the discretion that way, saying that our supplementary affidavit was out of order and all of that. And she didn't quote any law to support that, but she's saying that we had to get leave. There are things that sometimes you don't need to have leave. I don't think we need leave here to file an appeal, and so on. So there are cases, and where there's an absence of the law in relation to a specific action or activity that has to be done, you normally do it so in the larger corpus of justice is done, and or more clarity is brought to the issue. And that is what we did with the supplementary. So I don't know how she's kind of attempting an exclusion of it. But again, we respect her decision. We then move on to the next phase. And I want Guyanese also to respect that. We will have tremendous criticism of it, as we are exhibiting here through our pronouncements, and that is it. But of course, hers is what is dominant as of today, right up to when it is changed by a court of appeal. And we must learn, and these are the processes that help Guyanese understand their democracy, or that branch of it called the judiciary. As president of the bar once, I had a number of tasks to do, was to explain to members of the public how it is that we got these 3 branches of government, what it is, and how there is definiteness or finality and so on that is brought when it is judges' orders, until such an order is overruled by a higher court. And then finally the apex court, like in America it's called the Supreme Court, and the Supreme Court of Canada, the Supreme Court of India. When they make pronouncements, that's the end of the matter. You respect it and you move on. But if a judge make one, you go to the Court of Appeal, say, well, the judge was wrong, as we are saying here. And hopefully we will get it, ultimately the country will get it right.
Fantastic. Fellas, I'm watching us approaching program time very, very quickly, and so I'm asking my final question. There are numerous cases being prosecuted at another level in the judiciary relating to elections, alleged election offenses. Persons being prosecuted right now include the Chief Elections Officer, Mr. Keith Lewingfield, Claremont Mingo, Enrique Levan, Michelle Miller, Carolyn Duncan, Sheffrin February, Duarte Hesberger, Roxanne Myers, just a few of the GCOM staff, and there are also political persons being prosecuted by the state as well. Persons want to know, does anything concerning the elections petition and ruling affect those cases, and could those cases affect their rulings likewise?
Senior, you want to? I don't believe that they touch and concern our elections petition here, and even I don't see the connection.
In some instances, some of the litigants are trying to sneaking this question of whether there was rigging in the March 2nd election, because I noted in one of those cases they were asking at the magistrates court level for the SOPs, to see the SOPs.
Oh yeah, well, you're gonna get that wildness coming from some of these fellas who, if they want to prosecute, they can prosecute and they can carry on with whatever. Now, if that court were to ask for the SOPs and the SORs from the registrar, now that the Chief Justice has made an order, I wonder what will happen. But I don't know what right now is the connection between whether recount was constitutional or not, and all the irregularities that we would have presented in 99 got they want again a public relations exercise against a number of these individuals. And like I mentioned an earlier time, what the recount proved, Cheryl, was that there was a steal of the elections long before anybody else attempted it. Yes, and this is what the recount has shown. And the PPP are masters of this game. And they know how to do the propagandizing that they are archangels. And the devils and the demons are with the APNU AFC and a whole host of nonsense. But thank God we held out, that we don't want only Region 4. And then you saw the discrepancies and all the things all across in the ballot box, and some East Coast 49 of them ain't got none documents and so on. Why the PPP don't want to bring that out? They're saying that certain things now were at the hands of these individuals that they're charging. Well, I don't know what will happen there, and I rather suspect all of those charges are going to fall apart. And it is just for the wild propaganda exercise of carrying through with them, and in a way trying to drive fear into people. And that is what the whole thing is about. But I believe that people are not going to be fearful of them and the processes and all of that. If they want to set up cases against these people, they shouldn't be doing that oppressively. But you have it there that they have done that, and they are going to be defended by very good counsel, and hopefully that will take care of itself. As to whether it touch and concern some of the matters that we will be discussing in our petition, I don't think so. I don't think it touches and concern that. But you can say at a general level, they want to drive fear in these people. Because it's these people that will bring out all the irregularities of the recount. It was Lowenfield and a whole number of other people.
Thank you, sir. Royce, the final word goes to you, sir.
Oh, thanks. Well, Sherrod, the criminal charges have nothing to do with the election petition that is currently before the court, which is petition number 88. Absolutely nothing. The fact that the Chief Justice made those orders that those documents will be preserved, to me, means absolutely little, with the greatest of respect. They cannot be used in petition number 88. There's no relevance to the issues to be determined in petition number 88. And once a petition would have remained alive and before the courts, the Chief Elections Officer is not empowered in law to destroy any document.
That's right. You keep it.
So moving the documents from GCOM to the registrar. To the registrar. One, I believe that it may well be in breach of the act. If it is not, it would substantially make no difference because it cannot be accessed by anyone.
Great. And it will make the courts have regularly been proven to be a very unsafe places for a lot of exhibits and all of that, I don't know how safer it will be with the registrar, but it's a propaganda effect of it. Oh, look, Anil and the Lal call for the thing to be stepped in, and you're taking it away from the hands of somebody that has been charged and all of that. It is rather foolish. But in any event, I rather suspect that the Chief Justice might very well want to rethink and revisit her position on that issue, and and deal with it and ask herself the question whether she should remove it from a safe place. GCOM's precincts, I think they all are held now, and rather than put it in the compound of the judiciary under the registrar. do a
And
photocopy.
Rosedale Ford, Attorney at Law, Senior Counsel, Cameron Ramjitan, Attorney at Law. Thanks for joining. Thanks for stepping in the ring this evening and for walking us through some of the substantive issues in the election petition ruling on the preliminary matters that were brought before it and were ruled upon this afternoon. Thank you, gentlemen.
Take care, and thanks for being here too.
Thanks, Sherwood.
Great. Folks, there you have it. Again, Senior Counsel Rosedale Ford, Attorney at Law, and also Mr. Kemrat Ramjitan, Attorney at Law, both on the legal team prosecuting the issue of the elections petition 88 and 99. Folks, as we go, we continue to advise you and encourage you to observe all of the COVID-19 restrictions and the regulations that are in place for your health and safety and that of your loved ones, your friends, and your family. Social distance, wear your mask, watch the crowds that you are going to be liming in. It shouldn't be persons numbering more than 10. Sanitize every chance you have. Folks, we have to stem the tide and spread of COVID-19. It has been my privilege being in the ring with you guys. Ringsiders, I see you there. I see all the comments. Thanks for joining once more, and thanks for sharing this broadcast as well. Do stay safe. We'll see you